for delivery of judgment. Item 35, WBC 1916/25.
Writ petition is dismissed. Yes. For a query, if any, that no, we'll take it up because that file independently went to the section. So that's why it did not come to us. We'll check it and get it listed. You have the number? Just give a slip. Write it on a piece of paper and give it to the court master. I'll just check it up. Perhaps it will come after 6th. 2 or 3 days we have some difficulties. Yes, Mr. Dey. (18 and 24). Make it after 2 weeks, 18 and 24. Both sides are represented on the prayer made by Mr. P.C. Dale and counsel for the petitioner. This after 2 weeks. 16. (16 and 27). Okay. (8). Okay. When do you want? When do you want? List on. (7, 11, 25). Yes. This thing give it to the court master. Speak loudly. 22 and 33. 22, 33. (22 and 33).
32, 32.
32.
And adjournment.
Okay. After 2 weeks.
May I please lordship, I vexed noise item number 19, thing for adjournment.
19.
19, 1 name.
You want an adjournment?
Okay.
Okay. 2 weeks.
Dictate.
Item 1 for motion.
My lord, the record was confirmed not received, but I have got the, my lord, note, my lord, service report. Certificate copy of the survey report,
But LCR has not come.
my lord. My lord, this certificate copy goes to show that notice was was, there was a Lotkajari. The house could not be traced out.
Kathy?
It's eventually. Huh? My lord, better I should file, and my lord, I may be allowed to file. My lord, I have no photocopy. That is the copy, my lord. I will make photocopy. My lord. My lord. My lord. So I do not require filing any evidence.
Records was communicated by the email dated 15/10/2025, the records is not received. Most of the registry shall issue a press reminder for the reminder for the LCF for email notice for the process server relating next paragraph report. The learned counsel for the petitioner has submitted that in the meantime, he has received the certified copy of the process server's report indicating that notice was not properly served in accordance with law. On the next date of listing, the learned counsel for the petitioner may provide a copy thereof to the court with a copy thereof to the learned standing counsel for the appearing respondents. List on 7/11/2025. Just add this. If physical records cannot be sent, then a scanned copy of the records shall be sent to the registry for being placed before the court. We permitted you to publish.
My lord. Bibliography.
Item 2,
May I please, lordship? My lord, there is a, my lord, common order, my lord, that is page 36, my lord.
this is giving us trouble, Mr. Payang.
My lord.
This page 36 is giving us problems. Although it appears that there are 28 cases,
Yes,
but it appears that we have passed hundreds of orders. Where is the service report?
my lord, service report, my lord, I could could not, my lord, annex, my lord. That is why my last occasion, my lord, this matter was supposed to dispose of, my lord. My lord, due to, my lord, only I could not annex the service of report, my lord. T-shirt, report to special. That is why, my lord, LCR, PCR was called for. The similar situation, my lord. It's there, I think. Dispose of.
Mr. Pang.
Yep.
Gampura's notice board.
Yes.
Amba,
My lord, my serial number at page 4327.
page 27, we have marked it.
Obligement.
Disposed of. Para 17. Para 17. Bottom 7. या फिर reference so due to certificate copy this way it will paragraph 17 is change
Oblige.
Item 3.
My pleasure, Lordship. This is the next party order, my lord.
page
Order is at page number 75, my lord. Notice was not received by me, my lord. And as per the order, my notice was hanged, my lord. In the order, it is reflected in paragraph 3, my
what
lord.
is the service report
A service report I could not get, my lord. And then the record and there is a submission, my lord. There is another case is pending against a petitioner in Nagaon, my lord. Originally, she belongs from Nagaon, my lord. And in that case, my lord, she was appearing, my lord, presently. And it was registered in this impugn order is passed by the my lord, Learned Foreigners Tribunal, Sonitpur, my lord.
Which page?
My lord. Regarding the pending case, my lord.
Which page?
Regarding the
Mr.
pending
Rana?
case. Pending, my lord. I have a next, my lord. That is at page 55. Page 55 is the notice, ma'am. Yes, my lord.
Page?
Page 55 is the notice, my lord, the particular one. This is the case is pending now before the Learned Foreigners Tribunal, Nagaon, my lord. And notice was issued recently, my lord, and is now pending for WS, my lord.
Well. Mr. A.I. Hussain, I'm counsel for the petitioner. And so for the respondents. Page 75. By filing this declaration under Article 26 of the Constitution of India, the petitioner, namely so-and-so, has assailed the ex parte opinion dated 17/8/2017, passed by so-and-so and so-and-so. What is the statement, how you have come to know about this opinion?
On August of this year, my lord, some police personnel visited my residence. At that time, I was in my mother's house, my lord. Thereafter, I could learn that there is a case in Sonitpur.
Where is the statement?
Statement is at paragraph 15, my lord. Paragraph 15, page number 22.
On the ground that the notice was not served. To the petitioner, it is posited that the petitioner recently come to know about the said opinion. So it is also projected that another proceedings against the petitioner is which is registered as FT case number 2632/16 pending for disposal before the Foreigners Tribunal number 5, Nagaon. Next. Keeping the issue of, in view of the inordinate delay in receiving the opinion, keeping the issue of maternity open, the notice written over on so and so. Within 2 days, call for the relevant record from the concerned tribunal. Right. At this point, by issuing notices, the following email address of the Learned Tribunal. Next, the prayer for bail shall be considered on receipt of the tribunal's records. Next, however, in the meantime, if the petitioner named is so is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall produce a certified copy of the order before they shall cause production of certified copy of the order before the Superintendent of Police order Sonalpur, Tejpur. To bring the order to the notice of the State Authority.
My lord,
Response was-
I am continuously appearing in Nagaon before the Nagaon tribunal, my lord. Is, no protection.
We can't do anything because unless we have the record, we won't know. It's a 2017 opinion.
As per the order, my lord, just, Latka is very,
And, uh,
because I am continuously appearing in
no,
the
no,
Nagaon
in that
tribunal.
case,
And there is apprehension, I am
in that
here.
case, that the second proceeding is
Yes,
in
that's
fact the
it.
first proceedings of 2016.
Yes.
There you are absent,
My husband
You-
is
you
working
can-
there
no,
in.
whatever
Nagaon.
be. but there you could not be served notice. In this case also, you cannot be served notice.
In the
When
present
the
case, I,
police went, you again, you are in your mother's house.
no,
So it's
in
a,
the present case, I have got the notice and I have appeared, my lord, in the Nagaon.
no,
forest
no,
tribunal.
we find you very influential.
A short that may be given then, my lord.
No, we are
Yeah.
giving a date. The records, it will take
Otherwise,
some time
she
to
will be
call.
in trouble, my lord.
In that case, my lord, the second proceeding will be res judicata, I give.
When we were young boys,
Thank
then
you.
there was a TV serial in the Doordarshan, Bharat Brahman.
My lord, in that case, the second proceeding cannot proceed because he has been already declared.
On the, on the
No, whatever be,
same
but
time
we'll have to
period,
pass
both
an
cases
order.
were registered, my lord.
And
Could we call the other orders also? No.
not necessary, my lord. No. No, because my lord,
This can be sent there,
yes,
amalgamated.
yes, amalgamated. Otherwise, it will be a res judicata again, my lord. Because big,
Okay, then we also issue notice on that.
yes,
Just earlier notice we said, then the second notice.
if is this,
Also,
it is the same in one
The
person.
state is also put to notice that if the proceedings before the two partners tribunals are against this petitioner,
At Nagaon, no?
No, no.
why whether there would be any why the two they said two proceedings cannot be ordered to be simultaneously proceeded with in one tribunal. It's to be done at standing council for the FP matters shall obtain instructions on this query of the court.
My lord, I admit, my lord, if it is the same, they are the same in one person, then no issue, my lord, it will be.
It's okay, we have put a notice, otherwise we'll forget.
Then,
Next day, I'll forget what I have
Yes, yes.
said today.
Then
In order
they,
to remind myself,
yes, they have to demonstrate first, my lord, it is the same in one person, then only.
Item 4.
my lord. There, my lord, impugn order is a page number. This is contested case, my lord, 248, man. It is started from.
But take care, if you don't take good care of your clerks, you may also face some difficulty from us. The last record, just wait to them, last record. You have not taken care of your advocate's clerk and he has changed your name.
Yes.
Look at the first order sheet.
AI Hussain.
Then that means you don't take care of your clerk. Take good care, otherwise this will happen.
Then cause this my name is correctly.
We don't know about.
Otherwise,
about this. You expect us to be very meticulous.
no. Uh, 248 contested, my lord. 248 is the, my lord, impugn order. Yes, my lord. My lord, Deputy Commissioner of Police, Border Kamrup Metro.
We like, we like.
Item 5
Earlier.
for motion.
Please, your lordship. My lord, improvement order at page 39, lordship, expert order. Notice was not served upon my lord. Yes, lordship. Lordship, page 39. 30.
What is your statement about this knowledge?
Lordship, paragraph 10, lordship.
10.
10.
No, because this is a very vague statement. We may not even issue a notice. When was the NRC updated? You have not stated anything. When you came to know about it? Paragraph 10 is very, very vague.
Lordship, last NRC update during
No,
the
when I don't know, I personally don't have information. When?
19,
2019.
lordship.
Then. If 19 you are aware, then it's 6 years. We may not
Yes.
even issue notice.
And
It's
delay,
not the matter you take,
delay, I have stated paragraph 11, lordship.
huh?
Paragraph 11.
Paragraph 11. That can't be for 6 years. We can't accept. You think over, we'll give you time. We'll take it up on Monday. You think over. Both sides are represented on the fair made by and counsel to the petitioner list on 3/11/2025.
Obligation.
Item 6.
May I please, Lordship? Page 85, the impugn order. Petitioner is in jail now. Okay.
Is apprehended,
Already apprehended, Lordship. Apprehended.
already apprehended.
Already.
And just then say, It is submitted that the petitioner, namely Jabbar Ali, has already been apprehended and lodged at where?
It's jail in Gwalpara,
Matia,
Matia Gwalpara.
at transit camp Matia Gwalpara. Apprehended on 26/5/2025. Accordingly, it is provided that the the petitioner, namely so and so, shall not be deported out of the country without order of the court. Instead, the petitioner shall produce a certified copy of the order before the transit camp Matia Gwalpara, in charge of the transit camp Matia Gwalpara, to bring the order to the notice of the said authority. List on so and so.
If already not deported, Lordship, that part is necessary.
Pardon me?
If already not deported, Lordship, that part is
If
necessary.
already not.
Not deported yet. Obliged.
No, Mr. Fukan would have known.
Yes,
Not deported.
not deported. But
Item 7.
May I please rush?
Yes.
Impugned order is case 67,
Age
67, connection
67.
declared to be a foreigner of post 1970.
Okay, your name?
My name is my lord Hamida Khatun Meli,
your name.
J. Ahmed Melo.
And Mr. J. Ahmed, then counsel for the petitioner, and so for the respondents. Page 67. When you dated 28/7/2025. Asked in so and so, reference case number so and so. IMDT case number so and so, reference case number so and so. Notice returnable in 4 weeks, extra copies within 2 days, call for the record. The period for bail is opposed by the understanding of the FP matters. 10 days time to take bail or rupees 5,000 to the satisfaction of
SP border to bring.
police bond.
Manka sir. South Salman Manka sir.
Understand.
South Salman Manka sir.
South Salman.
South Salman. Manka, sir.
Published.
Item 9.
May I please lordship?
The tribunal's order, my lord, in page number 102, my lord. 100. Opinion is, my lord, page 102. 66 voter list, 1970, my lord. 1979, grandfather's name, father's name is, my lord, appeared.
Okay, you have to wait for some days for the bail,
My lord.
some delay.
My lord, the delay part, my lord.
No, if there's a delay, we are not granting bail. So we are using a thumb rules instead of hearing in every matter.
If order dated 15/7/2024, my lord.
You have
Yeah.
filed in September, 25th
September,
September.
my
There's a delay.
My lord. I have stated the delay part in
We are not granting just.
my lord.
We have, you see, we have extended a 1 year thumb rule.
My lord.
For 1 year, we are not asking any questions.
Yes.
If it is beyond 1 year, then we are not inclined.
Well, he is late due to his
What will
foreign
be-
various
what will-
illness.
What will be the very good reason?
Para 29, I have stated,
What have you stated?
para 29 of the writ petition, my lord,
What is the
page
ground?
page 21, my lord.
What is the ground?
Grounds, my lord, the petition has taken, my lord. He has been suffering various illness and my lord, due to some financial problem, my lord. These are, my lord. Fairly, my lord.
Come to page. Come to page 63.
My lord. 63. My lord. Tell it, my lord. Annex 14, my lord.
Oh, whatever way, page 63,
Yes, my lord.
you have landed property, you can't be poor person. Even if it is in Antarctica, you're still not poor.
My lord. You have persist, my lord.
No, not that. This will show you that we have seen something. And Mr. T. Sheikh, Land Council by the petitioner and also for the respondents. Opinion dated 15/7/2024, passed by so and so in so and so. Thereby declaring the petitioner to be a foreigner opposed to its abuse scheme. Notice written over on 110, 112. Extra copies of the progress for the record for the email address. Period for field shall be considered on receipt of records. In the meantime, if the petitioner, namely Sirajul Islam alias Sirajul Ali, is apprehended, he shall not be deported out of the country without order of the court. The petitioner shall cause production of a certificate copy of the order before the Deputy Commissioner of Police, City Guwahati, bring the order to the notice of the said authority. This from the Minister.
Item 10.
May I please the lordship, my lord? It's a contested case, my lord, and lordship will find the impugn order at page 79, my lord. It was passed on, my lord, 31/7/2023, my lord. But unfortunately, I got the certified copy on 4/11/2024, my lord. And in the meantime, my lord, one of my son, my lord, he had met with an accident, my lord, road accident. And unfortunately, one of his hand, my lord, got broken, my lord, he fractured. And it took a long time, my lord. Since I'm a daily wage earner, my lord, I could not approach before this honorable court. I have filed one advice slip, medical advice slip of Guwahati Medical College also.
Which page is that opinion?
Opinion at page 79. my lord. Next at 12 minutes.
Will not question the maintainability then.
My lord.
Heard Mr. Z. Hamad, Land Council for the petitioner and so and so for the respondents. Page 79, opinion dated 31/7/2023, passed by so and so and so and so. Thereby declaring him to be a foreigner post 25/1917 stream. The delay in assailing the opinion is explained by the Land Council for the petitioner on the ground that the son of the petitioner suffered with an accident which led to fracture in his hand, and therefore the petitioner, being a daily wage earner, could not approach this court on time. Next para, issue notice return over in on so and so 1/12/2025, extra copies within 2 days, call for the record. The prayer for bail shall be considered on receipt of records. In the meantime, if the petitioner, namely so and so, Akash Ali, Mohammed Akash Ali, is apprehended, it shall not be deported out of the country without order of the court. The petitioner shall call production of the certified copy of the order before the Superintendent of Police, Border, Morigaon, bring the order to the notice of the said authority.
Deeply obliged.
Supply item 36 for motion.
My lord, Mr. Pang will make submission in this lordship. 40 times. 40 time being lordship, he will hear, he is here lordship.
My lord.
He is coming, lord. He is coming. Also,
File has come.
But, in this case, the issue of res judicata was there. The last order, your lordship, indeed. I have inquired, my lord, there is no photographs in the document, in the record. No photographs. Now, issue, my lord, as this res judicata is not denied, my lord. The learned tribunal has, my lord, said that let them prove that he is the same in one person, he will ready to hear the on res judicata, my lord. But they are filing a simple petition that it is barred by res judicata, so it may not be proceed. Let them, they have filed in WS. Let them prove that he is the same in one person. The tribunal is ready to give, ready to, my lord, your lordship will find in your order at page 72, man.
Please go ahead.
He is not saying that he will not decide, but he is ready to frame a preliminary issue, whether it is the same in one person or not. If it is, my lord, he is the same in one person, the case will be dropped. But they are coming in apprehension, my lord, that it will not be dropped.
This is a submission of the halls.
My lord will find
My lord,
this.
they are to produce records. That was the order, previous order. They are not producing the
records,
records.
my lord. Record was
Yes.
not- No. It's to get the instruction.
That is
Get the instruction.
instruction,
Record was not there. Record was not called for probably. Record was not called.
instruction from home.
So, my lord, is. Yeah, instruction only. my lord.
Instruction
So,
from home.
Instruction, I cannot get instruction from a tribunal. So that's why, my lord, only I inquired from the police.
My lord, how
whether
the
there is
tribunal
photograph or-
passed the order, my lord, that also be looked into.
No, yes,
My lord.
yes.
My lord. My lord.
Because in this honorable court, my lord, in this judgment 3402/2020, the res judicata is, my lord, accepted. Here it is said, my lord, the matter in not such nature, for the reasons recorded above, we allow the petitioner to remand the matter concerned tribunal to consider the case of the petitioner afresh by giving an opportunity to prove the petitioner so and so and so and so is the same in one person.
My lord,
Yes,
my
that's
lord,
possible.
my lord, we have also judgment, my lord. The Taravanu case, the challenge was,
Yes,
my lord. My lord, we will give the decision, my lord. My lord, my lord.
always.
There are so many judgments by the Supreme Court, my lord. Even if the challenge is made against the notice, that was allowed in Taravanu case, my lord. Not required. That case, my lord, Johir Ali case, that is not relevant, but because in the second proceeding, the proceeding has contested, then again she was declared. Then he came to this honor court. That cannot be applicable, my lord. My lord.
Thirty-seven.
Maybe law. Last written instruction was called for medical regarding the petitioner.
Type 2 diabetes mellitus and systemic hypertension for 30 years.
Ischemic hypertension,
Yes, Lord.
then he'll be entitled to bail. On the strength of the said ex parte opinion, the petitioner has been taken into custody on 2/9/2024. So the background in which the present writ petition has been filed is indicated in paragraph 3 of the order dated 27/10/2025, and therefore comma not reiterated herein. Next, the learned counsel for the petitioner has pressed for his prayer for bail, which is opposed by the learned standing counsel for the FT matters, on the ground that as per instructions received by him, the petitioner has been released from the hospital No, he's still under treatment.
Yes, Lord.
He's on the ground that the petitioner is undergoing treatment at the Gwalpara Civil Hospital, and therefore the petitioner being a declared foreign national may not be released. Next para. Pursuant to order dated 27/10/2025, the learned standing counsel for the FT matters has produced a copy of written instructions dated 30/10/2025, together with letter issued by the superintendent of the holding center, Matia Gwalpara, dated 30/10/2025, as well as a letter dated 30/10/2025 issued by the medical and health officer -1, Roman 1, of holding center, Matia Gwalpara, from the contents of the letter of the medical and health officer -Roman 1, holding center, Matia Gwalpara, the petitioner, namely Shah SHH, Ali, Akand AKND, the declared foreign national, was lodged in the holding center of Matia Gwalpara, he is suffering from type 2, Roman 2, diabetes mellitus, MELLITUS, and systemic SYSTEMIC, hypertension, and according to the patient's disease history, is also suffering from obstructive pulmonary disease, acute gastritis, and soft gallbladder calculus from 25/9/2025. As per the doctors of the Multi Medical College and Hospital. Next paragraph. In view of the said medical condition of the petitioner, or the court is inclined to direct that the petitioner, namely so-and-so, be released on bail on compliance with the following conditions. The three conditions are there. One more. The petitioner shall appear before the office of the Superintendent of Police, Matia Kualpara. No, sorry,
Borpeta Mali.
Borpeta. Once a month. And shall not leave the jurisdiction of the Barpeta district without informing the said authority in writing in advance. Next para is the reports will come. The reports will come.
PCR.
Uh, 2710 order will reflect regarding call for LCR number. And fixed 29 number, 2911. That part, notice part number.
Next, by order dated 27/10/2025, the court has already issued notice returnable and notice. So accordingly, the registry shall call for the records through the following email address of the said concerned tribunal. It's para 7 last. Next, list on so-and-so awaiting receipt of records, 1/12/2025. Receipt of records.
Hello, Blush.
But we have given you conditions, 1 month, you'll have to appear.
Yes, ma'am. Yes.
Upgraded item 34 for orders.
ये भी लगा ये
34, yes.
there is delay in filing the appeal, my lord, 229 days, my lord.
229 days.
Yes, my lord.
What is the explanation?
Well, the explanation is, my lord, the judgment was passed on 25/7/2024, my lord. And we received the certified copy on 30/7/2024. Thereafter, my lord, on this on paragraph 4, my lord, page 3, the applicant thereafter on 3/8/24, copy of the order forward to the Deputy Inspector General, so-and-so, Delhi, my lord. Thereafter, my lord, on 9/8/2024, requested for the group for legal opinion, madam. But it was thereafter, my lord, on my lord, on paragraph 6, my lord, it was in time, the applicant said that on 15/8/24, my lord, the engaged Central Government Council furnished legal opinion. Legal opinion is furnished on 15/8 within months, my lord. And thereafter, there is, my lord, and the on 23rd/8, my lord, 2024, my lord, legal opinion forwarded to the Inspector General, my lord.
And there is my lord, on the director, my lord, the applicant, the deputy inspector general is signal dated 17/9/2024. Directed group center got it to approach Ministry of Law, so and so. Here, my lord, there is delay of 22 days, my lord. This first, my lord, from 20, my lord, 25/8/2024 to 17/9/2024. There is delays to 28 days, my lord. This is, my lord. And thereafter, my lord, this page 5, my lord, paragraph 10, my lord. The ministry, my lord, appoint, my lord, this on 17/12/24. My lord. There is, my lord, 90 days delay in ministry, my lord. Ministry, my lord. And thereafter, my lord,
Please tell us, in the meantime, has a contempt petition been filed?
yes, my lord, there's a contempt petition is also
When?
here, my lord.
What is the contempt petition number?
Hold on, my lord, okay. Contempt petition number, my lord, page 18, my lord, the 6/5/5, 2024, my lord.
Petition number?
6/5/5, 2024.
24.
Well, it was filed.
Having state. The status, that case.
But it is contempt notice is issued, my lord. In the meantime, we filed this writ appeal, my lord. That is true, my lord. So ultimately, there is delay in filing is 229 days delay, my lord. In fact, this appeal is filed after from filing the contempt petition.
In the memo of appeal, where is the judgment of the
Yes,
single
madam.
and single judge?
Judgment case, my lord, 180, my lord. 179. 179, my lord, start from 189. Basically, my lord, in my lord, our only, my lord, the grounds, my lord, this, my lord, when, in writ petition, my lord, there is no prayer to set aside the impugn order, my lord. Only one ground of this we have taken in our, my lord, this grounds, my lord, mainly, my lord. Page 14 of the our memo.
What is the
appeal,
recent judgment of the Supreme Court on the disability?
my lord.
If a person gets disability,
Yes, my lord. Only
what
this,
is the recent judgment of Supreme Court? It has come last month. Not even last month, this month.
I am not aware.
Even in training, if somebody gets disabled, we will be entitled to disable.
That is our ground, my lord, and only this initial writ petition was filed, my lord, to setting aside the dismissal, my lord. Subsequently, they filed another petition where to reinstate, but there is no prayer for, my lord, the setting aside the earlier order of dismissal, my lord. So that is our only ground before this honorable court, my lord. So
It's a very recent judgment of Supreme Court. I think I've read it this month only.
Recently, Supreme Court doesn't disabled person and take a even power.
My lord, otherwise the delay is not sufficiently explained, my lord. There is unexplained delay of 3 months before the respondent authority, my lord. And another 2 months delay, there is no explanation, my lord. Why the, my lord, my lord, it is reflected from their petition, my lord.
No, paragraph 10, my lord. Yes, my lord.
It is from, my lord, para 8 onwards, my lord.
Yes.
Para 8, it is mentioned, my lord, that the applicants state that page number 4 of their delay petition. My lord. My lord, page number 4, paragraph number 8, my lord. The applicant state that thereafter Deputy Inspector General Directorate dated 17/9/24 directed Fire B Cell Group Center so Guwahati, Law and Justice Kolkata for obtaining the final decision. Then, my lord, paragraph number 9, applicant stated accordingly the relevant documents sent to the said ministry. Then, my lord, paragraph number 10, my lord, that the applicant state that thereafter Ministry of Law and Justice on 7/12/24. So, my lord, from September to December, my lord, there is 3 months, my lord, no explanation, my lord, why the file is kept in 3 months, my lord, period, my lord. The petitioner is, my lord, terminated in the year 2014, my lord. So it is more than 10 years he is out of, my lord, service, and they are, my lord, keeping pending this file for 3 months without, there is no explanation, my lord. And in the next, my lord, paragraph number 11, your lordship may find. Then also, my lord, what is stated that after 1712, it is accordingly, approval was given on 20 February, my lord. So that is another 2 months delay, my lord, about 2 months delay. There is no explanation why the file was kept pending for approval for 2 months, my lord. So there is unexplained delay, my lord, in this case, my lord, and which proves the, my lord, conduct, attitude and behavior of the respondents, my lord, in pursuing the matter, my lord. I will place, my lord, 3 judgments of the, my lord, Honorable Apex Court, my lord, and this clearly, my lord, the principles of, my lord, condonation of delay, my lord, in this matter. Only 3 judgments of the Apex Court, my lord, I will place, my lord. One is of, my lord, is reported in 2012 to SCC, but I have, my lord, takes the decisions from Supreme to the AIMN.
Only at this stage, the decision is entitled some. Actually, I have not completed much of it. So, this, the effect, I have stated, that there is, in 3 months pending before the ministry, and thereafter, paragraph 11 also, there is 63 days delay, ultimately there is, delay, 2 to 9 days, I mean, it is clearly mentioned in there. Here, I'm this one, I have to place one judgment, the judgment, 2023 judgment, Here, there is delay of 479 days delay, delay. This is it is related to order of the reference court, But here, in spite of that, delay, the High Court, Honorable High Court, condoned the delay and the challenging the condonation did ordered the High Court disputation was filed before the Apex Court, So for this, I want to point out only for before the your lordship, the paragraph 27 of paragraph 27 of page 8. Page 8. When passing this order, this Apex Court considered the special Tahsildar land acquisitions so and so, and that case, and this relief and observation therein was now it is settled law. And when the delay was occasioned at the behest of the government, it would be very difficult to explain day-to-day delay. The transaction and of the business of the government was being done leisurely by officers who had no or in events or no personal interest at different levels. No one asked the person responsibility in processing the matters expediently. As a fact, at several stages, they take their own time to reach a decision. Even in spite of pointing at the delay, they do not make expedient action for ultimate decision for filing an appeal. This case is not. This case is one of such instance. It is true that the Section 5 of Limitation Act envisages explanation of delay of the satisfaction of the court in matters of Limitation Act made no distinction between state and citizen. Nonetheless, they adopt the strict standard of proof leads to grave miscarriage of public justice. It would result the public mischief by skillful management of delay in process of filing an appeal. The approach of the court should be a pragmatic, not pedantic. Under such circumstances, the subordinate judge has rightly adopted the correct approach, had condoned the delay without insisting upon explanation of everyday delay in filing the review application. In light of the law laid down by this court, the High Court was not right in setting aside the order, delay was rightly condoned. This was, my lord, it was, my lord, 1996 as well, but it was considered when passing this order. Thereafter, my lord, paragraph 29, 29, my lord, considering the first decision, there cannot there cannot be a quarrel that the court has stepped in the ensured the substantive justice of private parties and state are not defeated at the threshold simply due to technical consideration of delay. However, this decision, notwithstanding, we reiterated that condemnation of delay being a discretionary power available to court. Exercising of discretion must necessarily depend upon sufficiency of further cause shown and degree acceptable of the explanation, the length of delay being immaterial. Sometimes the due to the want of sufficient cause being shown or an acceptable explanation being preferred, delay of short range may not be condoned, whereas in certain cases delay of long can be condoned if explanation is satisfactory and acceptable. Of course, the court must distinguish the explanation and excuse, and an explanation is designed to give someone all of in fact, and lay out the cause something. It helps clearly circumstances of particular event, allows the person to point out that something he has happened is not his fault. If it is really not his fault, care must be taken distinguished with explanation and excuse. Although people tend to see explanation and excuse as the same thing and struggle to find out the difference between the two, there is a distinction which to find is real. The excuse is often offered I'm this paragraph 31, my lord, of the judgment, my lord. The order silence under this appeal is dated on 21st December 2011. It was rendered at a point of time the decision of Kajik Supreme so and so so and so, we're holding the field. It is not that the said decision, said do not hold the field now, having been overruled by any subsequent decision. Although there have been some decision in recent past, so and so, which have been accepted governmental lethargy, thirdness, and the indolence in presenting appeal within time as sufficient cause for condonation of delay. Yet the exercise of the discussion by the High Court has to be tested on an of the liberal and the justice-oriented approach expounded in aforesaid decision, which have been referred to be above. We find that that the High Court in the present case assigned following reason in support of this order, especially others are the D. Further distinction, next page. Further a distinction should be drawn between the inordinate explained delay and explained delay. Delay where the present case, first respondent had sufficiently explained the delay on account of negligence part of the government functionaries. Functionaries and government council on a record before the reference court. Therefore, the officer responsible for the negligence would be liable to suffer. The officer responsible for the negligence would liable to suffer, and not the public interest through the state. The High Court felt inclined to make a pragmatic view since the negligence thereon did not border on colousness. So, this what happened, this pending before the ministry and as well as the other department, that is only this the officers matters. So then these judgments speaks because of that this the honorable court may consider that part So ultimately this when the high decision of the High Court in this judgment the apex court says yes, it is rightly passed. And it was condoned. It is 470 days delay was condoned, madam. So my humble submission, because this when the approach to file the appeal this the initiation is within month, madam. Within month, the order was passed at 25/7/24. Order was passed, my lord, 25, and thereafter, my lord, this legal opinion was sent on 15/8/2024. It was within time, and thereafter, my lord, they sent for legal opinion for Inspector General so and so on 23rd. So it is also within time. Whether do we file or appeal or not, this has to be considered by before this honorable court, because other part not. And there is another judgment of this of our High Court, my lord. This IA, passing IA 1-43/2017, my lord. Here also says, my lord, this, whether the department did want to prefer appeal or not, that decision was taken in time or not. So here also this, the judgment and order was passed in 16/7/2015. But ultimately there was some delay, my lord, delays, my lord, delays to 297 days delays here. So here the discussing all this judgment of the apex court, our high, in this case, the our high court and the delay the condone because the department now take a decision to file the appeal in time. In time. So, but the others, this, whether it's pending on some official capacity, it is different. But whether the department is trying to file and think about the file in time or not, that is there. So this is the I placed it to the husband and completely whether there is sufficient explanation is there not, that will be decided by this honorable court. Only my humble submission is that there is only this. In fact, I admitted there is delay in a ministry also as well as this the other office also. But ultimately, my lord, the decision was taken in time. This is my humble submission before this honorable court, and I pray before this honorable court to allow this my condonation petition.
My lord, in my first judgment, my lord, only 2 paragraphs I will refer, my lord, regarding the Honorable Apex Court, my lord, in case of, my lord, Isha Bhattacharjee versus Managing Committee, my lord, in my first judgment. Paragraph 15, my lord, there are some guidelines formulated by the Honorable Supreme Court, my lord, in regarding the, my lord, continuation of delay. I will, my lord, read only few, my lord, paragraph 15, in page number 11 of my lord, compilation, my lord. The principles, my lord, paragraph 15, page number 11, my lord. Isha Bhattacharjee, my lord, and Managing Committee, Raghunathan Nafat. Isha Bhattacharjee, my lord, it is reported in 2013, 12, 649. So, my lord, paragraph 15 is there in page number 11, my lord, of my from the aforesaid authorities, principles that can be broadly be called out. There should be a liberal, pragmatic, justice-oriented, non-pandemic, non-pedantic approach while dealing with an application for conditional delay, for the courts are not supposed to legalize injustice, but applies to remove injustice. The term sufficient cause should be understood in their proper spirit, philosophy, and purpose, regard being had to the fact that these terms are basically elastic and are to be applied in proper perspective. Number 3, substantial justice being paramount and pivotal, and technical consideration should not be given undue and uncalled for emphasis. This technical, my lord, is the sufficient cause. No presumption can be attached to deliberate causation of delay. Here is a case of deliberate delay, my lord, of 3 months and 2 months, my lord. Gross negligence on the part of the counsel or litigant to be taken note of. Lack of bona fide imputable to parties seeking condonation of delay is a significant and relevant fact. It is to be kept in mind, adherence, strict proof should not be affect public justice and cause public mischief, because courts are required to be vigilant in that ultimate eventual. Number 7, the concept of liberal approach has to be encapsulated in conception of reasonableness and cannot be allowed a totally unfettered free play. So, my lord, liberal approach should be on reason, my lord. Number 8, there is a distinction between inordinate delay and delay of short duration. It's very important, my lord. It is a case of inordinate delay, my lord. Inordinate delay or a few days for the former doctrine of prejudice is attracted, whereas to the latter may not be attracted. That apart, the first one warrants strict approach. So, in case of inordinate delay, my lord, the court's approach should be strict approach, my lord, whereas second calls liberal delineation is required. If it is a short duration, my lord, the guideline is that it is liberal, but in case of inordinate delay, it is of strict approach, my lord. Number 9, the conduct, behavior, and attitude of a party relating to its inaction or negligence or relevant factors to be taken into consideration. It is so fundamental principle that the courts required to weigh the scale of balance of justice in respect of both parties, my lord. This is a case of, my lord, 10 years before, my lord, the petitioner was, my lord, terminated, my lord. and he got a judgment, my lord. Two writ petitions filed before this honorable case court earlier. In the first writ petition, my lord, it was remanded back, then rejected, my lord. Then again, the second time, my lord, they have the honorable court directed for consideration, my lord. So in this period, 10 years, my lord, already elapsed. And my lord, the conduct is that, my lord, the departmental officers kept pending, my lord, the matters for 3 months and 2 months. I have, my lord, mentioned that. So, my lord, next, my lord, can the explanation offered is concord grounds urged in the application are fanciful. The court should be vigilant not to expose the other side unnecessary to face. There is not a single word, my lord, of the 3 months delay, my lord. So, my lord, there is not a single word, my lord, single sentence. Then why 3 months period and 2 months period was, my lord, kept, my lord, without explanation, my lord. How this 3 months period, why, my lord, there is no explanation, my lord. So, my lord, may I read paragraph number 16, my lord, next paragraph, my lord, page number 13. To the aforesaid principles, we may add some more guidelines. Apex Court has some 4 more guidelines, my lord. An application for conditional delay should be drafted with careful concern and not in a haphazard manner, harboring the notion that the courts are required to condone delay on the bedrock of the principle that adjudication of a lease on merits is seminal to justice dispensation system, my lord. So the petition is drafted, my lord, without explanation, my lord, these 3 months and 2 months delay, my lord. My lord, paragraph, my lord. My lord. My lord, I have not served the memo of appeal, my lord, because, my lord, this memo of appeal is not registered, my lord. I have not served the copy, my lord.
You have not served.
My lord,
Not registered.
not my, because
Why you are saving money? Doesn't help you.
no, my lord, my lord, here, my lord, the initial, my lord, when I filed, my lord, only.
No, at least give him a copy. We are asking questions, he can't
Yes.
reply.
Yes, my lord.
Your matter would be adjourned for no reason at all. He's entitled to a copy.
Yes, my lord.
Give him a copy. You take it up again on Friday.
On Friday.
Do you have a document in the memo of will
Yes, my lord.
showing the date on which the petitioner was, the respondent was enrolled as a member of the force?
My lord.
Any document showing that
No,
the
my lord, not,
respondent was?
my lord, actually, this after or taking out oath, my lord, he will be a member of this, my lord. Training,
Where is the document that he has not taken the oath?
my lord, this training period is not completed, my lord.
But give him a copy, he must
Yes,
respond to the court query.
My lord, can it be on 12?
Well, what man aparo?
12 na time. 14 of time. 12, 14.
Aparo.
12, 14 na time.
Quoting on that, sir.
Hotel was a Friday, 7.
Hmm?
7 of the
7. 7 or assume. Oh, that can go good, sir. Whatever, whenever they want, sir. 14 8 মান নাথাকো তাৰমানে পুৰা নাথাকো সেইটো সপ্তাহ নাথাকো অৰুণাচলত থাকিব 17 ছিল 18 খুলি দিব 18 19 19 18 hearing with us. Fix. बहुत फास्ट लग रही है मौसम पिछड़ लगा मौसम पिछड़ लग रही आइए बोला 18 को वर्किंग hearing में सब फिक्स है हाँ तो फिक्स है पहले पढ़ रहे মিসপ্লেস করে এগুলো এটা অরিজিনাল কাগজ নাই ফাইল করতে হেরানো না নাম itu mana itu uliar so itu tak baca kalau itu uliar itu pun itu an ini bilang ini adalah antar peralatan ini adalah kita tak perlu teksi kan kita tak perlu teksi itu juga kami kita menggunakan kalau zoomnya dia buat kerja mesti lagi itu kan menggunakan idea menggunakan sertifikat kerja uliar 18 तारीख 19 तारीख मतलब in CRPF itself rules is there मतलब CCS conduct rules CCS conduct rules तो लड़के का आना लड़के का आना बहुत डाउट देखो तो अच्छा कर ले हां और रेड बुल रसल प्राइमरी रेट इतना है सीसीएस में जैसे ऑर्डर दैट ऑर्डर इनके नॉलेज पर्सन इसलिए My lord, here, my lord, temporary service rules, my lord, 1965, my lord. Civil. My lord, next. Yes, my lord. My lord, my friend has personal problem on 7, he told me. So, my lord, may I, on my lord, this next, then.
Number 19th, my lord, 19.
That will be too late. Your contempt is there.
Yes, my lord.
When is the next date of contempt?
Well, it is not listed, my lord, till.
Then my lord is 12, my lord.
My lord, 12, my lord, on that, I'll be in Arunachal, my lord, for 5 days, my lord, from 11 to 15, my lord, on 18, my lord, my lord.
My lord, 18, I have some.
18 and 19,
weeks,
my lord,
my lord.
19.
In the meantime, you both of you give your list of books and the paragraphs also.
Yes, my lord.
Just indicate the paragraphs.
Yes, ma'am.
The list of, give it to the court master well in advance.
Yes.
Give it back. Give the paragraphs and then write your names and then
Yes, ma'am.
both sides are represented. The learned, Mr. S.K. Mehdi, learned CEC shall provide a copy of the unregistered memo appeal to Mr. M.J. Kadir, learned counsel for the respondent. Next para. List again on 12/11/2025.
My lord, 12, my lord, I will not be here, my lord.
Then
My lord, 19 he proposed, my lord, 19, my lord.
19, okay, 19, 17.
Upgraded item 16 for admission.
My lord. My lord, the impugned order, my lord, page number 36, my lord. Now, the grandfather's name, my lord. My lord, my written statement is annexure 1, which is page number 30, my lord.
Who came and proved the Kabinama?
My lord,
Exhibit 3.
the issuing authority, DW, my lord, DW4, the last page, my lord. The last page of page 83 of this writ petition, my lord.
Yes.
My lord, page 83, my lord. DW4.
Doesn't help you too much.
My lord. But it is very clear that he issued it, my lord.
The
Relationship
certificate
with
is not in accordance with the 1935 Act.
the old record was also brought, my lord.
Pardon me?
The old record,
Of
may I read, my lord, the entire part? It
page
says,
number, you're reading which page?
83, my lord, DW4. Page number 83, my lord.
Yes.
I have been serving as the Qazi of the Muslim Register, Hazirat, Assam since 1997. In Exhibit 3, the date of the marriage is written by me, but the other contents of the certificate is written by one assistant. Exhibit 14 is the marriage register. Exhibit 14.1 is the original page of the said marriage register. And Exhibit 14B is my signature. In the Exhibit 14, the date of the marriage is overridden by me. In the said register, there is no mention about the age of the bridegroom. In register, I have not taken signature of the guardian of the bridegroom. I have not complete the column 10, 11, and 12. I have not mentioned the date of registration. But he is authenticating it, my lord, with the old register, my lord. which is just 14(1)(b.
The date of registration is not there, it's not there.
My lord, this particular annexure is page number 52, my lord, the vernacular one.
Yeah.
Here, this date is mentioned 31/7/2004, my lord. This is for the limited purpose of proving the linkage with the father.
This is your first voters list.
My first voter list, my lord.
Yes.
My father's voter list is there, grandfather voter list is there. The petitioner voter.
Yes. He would be. Yes.
Apparently she was a D voter, my lord, so certified copies are not issued in her favor.
Yes. 2005.
Who are your witnesses?
My lord,
Who are your witnesses? You came as DW1.
yes, DW1, my lord.
Then who is the second witness?
Second is the father, my lord. Page number. Huh? Oh. My lord, DW2 is page number 81, my lord, the father, whose name is there in the 77, along with the grandfather, my lord. Page number 81, my lord. Mojo Sheikh. And this deposition were not demolished, my lord.
Page number?
81, my lord.
No, 81 is cross-examination. Where is the in chief?
The evidence? Evidence of DW2, my lord, is page number 77.
See, this,
My lord,
if this deposition is correct,
my lord.
then it demolishes your marriage certificate. Can you find out why?
Why, my lord?
No. You look at the marriage certificate, the Kabinnama.
My lord.
I don't know how you will, how it can be reconciled.
My lord.
Before that, come to paragraph 3 at page 77.
Yes, my lord.
She got married to so and so, he was assassinated. Correct?
My lord.
You've seen that paragraph 3, page
Yes, this is
77.
the first marriage, my lord.
We are still there.
My lord.
But look at your marriage certificate. There the Qazi tick marks talaki. If there is a death, there won't be annulment of Muslim marriage.
My lord, the death certificate also annexed.
That's why we are saying that if this is accepted, then your marriage certificate goes. It is, that's why you said, I told you, how you'll explain and how you understand this will be relevant. In a Muslim marriage, does death annul the marriage?
It's not talak, definitely. It is not talak.
But in the certificate, it is talak. So the second, that's the second marriage certificate contains a wrong entry. It's okay for this question of citizenship is not relevant.
Yes, my lord.
Uh,
Here, my lord, the relevant portion is she the daughter of Moshe? So that clearly stand out, my lord.
The problem in your case is that your grandfather, you have given 6 or 7 alias, not one. 1 or 2 can be understandable. 5 or 6, 7 is
Lord,
alias.
This is with
Makes it
almost
very
all
difficult.
names, my lord. Even I check my 2005 name, there is also my half name is written with.
Doesn't happen. For good people, it doesn't happen.
My lord,
For good people, many good people we know, it doesn't happen.
but I have seen generally, my lord, it happens. My personal experience, my lord. Generally, it happens.
It doesn't happen.
Earlier, what happened, my lord, the enumerator used to write the name. Mostly, he used to sit at one
Just
place.
would not happen. 1, 2, 3, 4, 5, 6, 7, 8, 9 alias.
But these are all Muslim Isab.
And where is the voters list?
My lord, the grandfather first voter list is page number 55.
Yes, 56.
Page number 56, yes, my lord, the vernacular.
Then page 58 is the second one.
Page 58 is the second one, my lord, 70. And then, my lord,
Village, there's a change in village.
my lord, these are in the same location. Xerox to go. I can show you, your lordship, the Google location.
Yes.
My lord, this Mandirpara and Bhutia Danga. So Bhutia Danga starts from 70 and 60 is Mandirpara. Same location, my lord. Must have shifted from this one place to another. But the same, almost, I am told, my lord, this is this part of the road as the Google map shows, my lord. Bhutia Danga is the other part of the road. So, okay.
Whose death certificate was that? Sahidur Rahman? Who is he?
First husband, my lord, probably. First husband was Saidur, second was Bosirul. Shahidur is the first husband.
Lordship. Yes, Lord.
If that Kavinnama goes, then perhaps you have no link with your parents.
Yes, Lordship.
Contains the state emblem for which it was rejected.
Now the school certificate is also there.
Yes.
School certificate appears to be doubtful.
My lord.
Yes, yes, Lordship.
In both your documents, there are overwriting.
Yes, both.
The marriage certificate comes, the Kavinnama, there is an overwriting. School certificate comes, there is also an
But
overwriting.
he says that I have, Kazi says I have written it, my lord. And my only submission would be, my lord, these
We'll
documents,
examine it.
my lord, my lord,
We're not discussing it right.
my lord.
Lordship, even Lordship, procedure also don't know when her marriage was solemnized, Lordship. It was mentioned.
Can't say. But this has been able to show that it is nearby, so therefore.
Maybe nearby village, but different village, Lordship.
Old building, new building. Otherwise, to 70 पर ऐसा area पे ऐसा 70 पर ऐसा नहीं होता 70 पर 62 मिलेगा
Document na ako.
70 70
70 kilometer, 2000 something document na. Grateful, my lord.
We can immediately dismiss and make you free. Why we should make this stand? No. Which item?
23, my lord.
Okay. Okay, we'll take it up.
Upgraded item 27.
My lord, the impugn order, page 17, my lord, is an ex parte order. The relevant portion, my lord, page 19, para 7. No, it was not served upon me, my lord. What happened? The portion of the village that has been eroded away. And I just checked the LCR, my lord, page number 19 of the LCR. The Gaubura also says that that place is, he says, drawn. Cannot be drawn, it will be eroded away, but that's why I was not found in that village, my lord. Lokhipur, that part of the village has been eroded away by the river. It's a riverine area. Yes, yes, Lordship. The above person lived at Lakshmipur village with widow death. Yes, yes, yes.
Brown.
Yes, brown flag. Lordship.
Well as so and so for the respondents. By filing this writ petition in Article 226 of the Constitution of India, para 2 of order dated 24/9/25. Para 2 of 24/9/25. Next para. Next, referring to the service report as well as the certificate dated 27/4/2023 issued by the in charge Gaon Pradhan of village Moricha, Moricha, next word, Kandhi, Kandhi, and Lakhipur, charge number 11. It is submitted that the house of the petitioner was inundated public eroded due to river erosion of due to erosion caused by river Brahmaputra. And therefore, notice which was served by pasting it in the notice board of the Gambura is not a proper service. Next one. Per contra, opposing the opposing the challenge to the ex parte opinion, the learned standing counsel for the FP matters has submitted that after the reference has been made, after inquiry was made by the police personnel, it was incumbent on part of the petitioner to inform the competent authorities in the Home Department before, in the border police before shifting her residence. And therefore, as the petitioner did not inform the authorities about the change of residence, notice is deemed to be duly served. Next paragraph. As per the process service report dated 28/4/2023, the house of the petitioner could not be located. And therefore, after taking the certificate by the Gaon Pradhan, a notice was pasted in the notice board of the Gaon Pradhan. Stop. in the certificate dated 27/4/2023 issued by the Gaon Pradhan, it has been mentioned therein as follows, give a dash, then inverted commas. The above person lived at Lakhipur village before 1997, full stop, but I don't know where he lives after being drowned, DROWNED, drowned by the Brahmaputra. Inverse, full stop, inverted commas. Next part. As the petitioner has opposed this court, it cannot be accepted that the petitioner was drowned in river Brahmaputra. Stop. Therefore, the only view that can be presumed is that the house of the petitioner was eroded by the flooding of eroded by river Brahmaputra. Also, the house was lost due to erosion of river Brahmaputra caused by river Brahmaputra. Next, under the circumstances, the what is of the considered opinion that as the house of the petitioner was lost due to river erosion, and the notice was not served at her last place of residence, the petitioner deserves an opportunity of contesting the proceedings. Accordingly, the ex parte opinion dated 2/8/2023 passed based on so is hereby set aside, and the matter is remanded for a fresh opinion by the learned member from Foreigners Tribunal number 7, Borpeta. Next, accordingly, it is provided that the petitioner, who is duly represented by a learned counsel, shall appear before the Foreigners Tribunal 7, Borpeta, within the outer time limit of 1/12/2025, and by producing a certified copy of this order, file a written statement of defense and produce all the documents on which she intends to rely upon, without waiting for any any notice to be served, without requirement of any service of any notice to the petitioner for appearance. Next, upon appearance of the petitioner, the learned tribunal shall grant sufficient time to the petitioner to a reasonable time to the petitioner to her documents and to produce the witnesses. Next paragraph, it is made clear that in the event the petitioner does not appear within the outer time limit provided, it shall be open to the learned tribunal to treat the petitioner as absent on call and pass its fresh opinion in accordance with law. Next, the registry shall send back the records to the concerned tribunal. Next, the petitioner shall produce a certified copy of the order before the Superintendent of Police order, which place? Borpeta. Borpeta to bring the order to the notice of the said authority. The state petition stands at disposal. Grateful minute.
Item 11 for admission.
None appears on call for the petitioner. However, all the respondents are represented. Next. In an earlier occasion, or due to continuous default on part of the learned counsel for the petitioner to be present, the court has appointed a learned amicus curiae by order dated 28/4/2023. However, subsequently, the learned counsel for the petitioner entered appearance on 15/11/2023, 22/11/2023, and 30/11/2023. Therefore, this court by an order dated 30/11/2023 discharged the appearance of the petitioner of the learned amicus curiae. However, when the matter was again taken up on 22/10/2025, the learned counsel for the petitioner had defaulted in appearing. However, Miss P. Begum, learned amicus curiae, still appeared as her name was reflected in the cause list, which was appreciated, but as he was relieved by an order dated 30/11/2023, her willingness to assist the court would not be accepted, as she was already relieved of further appearance. Next, be that as it may, when by the last order dated 22/10/2025, the court had made clear that in the event the learned counsel for the petitioner remains absent on the next day of listing, this orders with as the petitioner, as the counsel for the petitioner remains absent on call. What is of the constitutional opinion that what is of the view that the petitioner will not desirous of pursuing this petition according to this petition stands dismissed for default on part of Mr. J.C. Bugoi, the former learned counsel for appearing in the matter on call. Next one. For the way it makes sense. This is the thing. Things the registration sent back the travel reports along with a copy of this order just to enable the learned member, the concerned foreigner's travel to make it a part of the report.
Item 12 for admission.
Lordship. Lordship, in this matter, your lordship, I want to withdraw my wakalat, my lordship.
You want to withdraw?
Yes, your lordship.
Then just don't appear because we can't accept your prayer for not appearing.
Actually, your lordship, I have been instructed by the other.
We
guest
don't know
counsel.
about that. Once you accept your wakalatnama, we understand that you are there. If you want to relieve yourself,
Since
there are
long time,
there
your
are
lordship,
certain.
there has been no communication with the
We
client.
don't know about that.
In that case, your lordship, I may be allowed to send a notice to the client, your
You
lordship.
do whatever you want. You don't need a. Do you need a court's order for that? We are not giving you any opportunity for that. Whatever you want to do, you do. We'll just adjourn it on your prayer. on the prayer made by Mr. K. Midar and the Council for Krishna, the matter stands adjourned today. All the respondents are represented. This being a pending matter, list again, will give a date after 2 weeks.
Item 13,
Lordship, matter may be adjourned for the day, Lordship. Yes, Lordship, but we don't have the file, Lordship. Youngest counsel, Mr. K.R. Islam is no longer in practice. Thanks, Lordship, I know. As Nazneen, on behalf of Mr. H.R. Sotram.
Yes.
upgraded item 23 for admission.
May I please, Your Lordship? My lord, as per the direction given by the Honorable Court on 25/9/2025, my lord. Actually, I appeared before the Superintendent of Police, condition number 8, my lord. There was a condition number 8, my lord. The petitioner shall appear before the Superintendent of Police Border, North Lakhimpur, with a certified copy of this order. I appeared, my lord, and in fact, that very day, the SP was very much present, and my lord, who had allowed me to go, but by taking a bond, my lord. Of course, this is transmitted to me in my WhatsApp, but this is not that legible. So kindly allow me to file one application, my lord. Yes.
What is the best document you have to connect you to your projected parents?
My lord.
What is the best document you have to connect you to your projected parents?
My lord, there is a document from Sultanpur, UP, page number 30 to 31, my lord, 30 and 31, which goes on to show that my mother is from Sultanpur, who had married to my father, and out of that, 2 sons were born. One is Idris Qureshi, the other myself, Shafiq Qureshi. Idris Qureshi, there was my lord, FTC case in which he was declared to be, he was 5 years younger to me, he was declared to be Indian. That I have also annexed, my lord. And the same document was relied upon there, but is not relied in this case, my case. Page number 32, my lord. Sorry, page number, my lord, this 30 to 31, 31.
This is something which is, I don't know why the state has not come in appeal. You see, the simple reason is that you don't follow material system of family. Therefore, you cannot draw your citizenship through your mother. Because once you have been issued notice, then section 3 would not apply.
My lord, what happened in this case? Let me submit before your lordship. Actually, two cases were running simultaneously. I had kept a lawyer who was also the lawyer of my brother. Those two, I mean, the Wakalatama is very much there. What he
We cannot
instructed
accept-
me,
We can't accept that. You forgot to add learned lawyer.
my lord, but the thing is that I have been rather deprived to agitate my cause by a lawyer, my lord.
Learned lawyer.
Learned lawyer, yes, my lord. Learned lawyer.
You can't
Because
do
when
anything.
he fought the case for my younger brother, he said that as he is acquitted, you need not to come. I never went to. And the order was passed against me. Then I came before your lordship, and in this another writ petition, number 1735, the matter was remanded back. That I have also annexed, my lord, at page number 27, 29. And then I
Yes.
was given the opportunity to agitate my cause before the learned tribunal. I agitated my cause. My respectful submission before your lordship is that when the same documents were considered in my brother's case, that he is an Indian, I am elder to him, why I should not be declared as Indian, my lord. And my lord, it will be too discriminatory to say that I will draw my citizenship from my father. No, from my mother also. Mother is from Sultanpur.
Once a notice is issued under section 6, because once you cover by that, then section 3, 4 will not apply.
My lord, your lordship is absolutely all right, but they should know about that. We are the victim of, my lord, we are the
That is why
victim.
we are saying we are surprised that the government has not filed an appeal in that earlier case.
We are the victim of, my lord, learned lawyers, of course. I don't know, my lord, in many of the cases, of course, I have having only two cases before your lordship. One is from Rajasthan, the other is from UP.
But you see, the problem is that at the time of inquiry, you were here. And it is not the requirement that the inquiry about the suspected foreigners cannot be carried out at a place where he is found. The certificate on which you relied on, the mother's certificate,
Exhibit 1, man.
yes. You see, even your this form does not fill up the name of the mother. And the second part is serial number 2 of that, note number 2.
Yes, para 7, my lord.
No, this certificate, para number 2.
Yes, my lord. Domicile, this one, my lord, here, Patni Shri,
No. Serial number 2, down below.
yes, my lord. उपयुक्त की पुष्टि
Prarup.
प्रारूप नंबर 1, my lord, मैं आवेदन एवं सत्यापनकर्ता द्वारा
Satyapan Karta.
उपलब्ध,
That means
yes,
the person who has sworn the affidavit.
yes.
So I will go swear an affidavit, say that I am the President of India. Maybe perhaps you will not believe me. I really want to be known as.
My lord, but my lord, this statement can also not be disbelieved.
Not on the basis of any inquiry. This is on the basis of an affidavit.
Affidavit made by made before the this Gram Panchayat or something, and then they reported.
You know more than us. Self-serving affidavit, how much it is reliable upon. That's why I said, I gave an example.
My lord, सत्यापन कर्ता द्वारा, the person who is the deponent, सत्यापन कर्ता द्वारा means the person who is the deponent, उपलब्ध कराई गई सूचना तथा इससे संतुष्ट हो जाने के उपरांत. So my lord, the authority of UP is satisfied. But my lord, that is the process to issue this certificate, and which I have followed. My lord, if I am to pass matric, I must go through class 1 to 10. No, my lord, I have not. But my authority is satisfied, my lord. Yeah. No. My lord. Yes, my lord. My lord, the same thing happened before Allahabad High Court. Lawyer was one and the same. In the morning also he was right, and in the afternoon also he was right. Let it be some other day, my lord. Oblige, your lordship. Fourteen, 13 করে দিও প্যান্ডি, 13 করো, নাইবা 16 আর পিছত করো। 13. Oblige, your lordship.
Single bench, item 1.
Speaks only for that law point versus whether 47 meetings compile or not. Before starting the may I get also with the mandate of article 22(1) versus article 22(1) or 16 possible. CRPC services. Article 20, I am reading it from the Vihan Kumar judgment.
it mentioned it, it is quoted Lordship. So para 9 in the Kumar case. Article 22(1) of the Constitution, which under 22 protection against and detention in certain cases. Article 1, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. So to my understanding also that that person who is being arrested, he should know that why he is being arrested. And the second part, at the same time, there is second part also, and that he should be so that he can also engage one person of his own choice, one counsel of his own choice to defend him. And Joseph, section 50 of CRPC also. CRPC Section 50 also. May I read that section 50 also? Section 50 laws of CRPC laws. That that is 47 or now it is 47. Section 50 laws. Person arrested to be informed of ground of arrest and of right to a bail. Every police officer, every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested. So it is stated also that full particulars of the offence for which he is arrested, or Lordship, here it is mentioned, or other grounds for such arrest. So Lordship, teaching Lordship, maybe communicate to him Lordship first, Lordship, that the full particulars for his arrest. The full particulars mean Lordship that the case number, sections, and that whether it is bailable number, that is the full particulars of his arrest, and other grounds for such arrest. All that is mentioned Lordship. So Lordship, this is Lordship the mandate Lordship. So Lordship, the Honorable Apex Court is a constitution bench Lordship in A.K. Gopalan case Lordship. That is Lordship reported in 1950 SCC 228. In A.K. Gopalan case Lordship, that is para 350 Lordship. May I read that part also? Yeah. 1950 SCC 228. Para 350. This is the judgment Lordship. That Lordship, the article says has been clarified Lordship. Some elaborate discussions are here also in this case Lordship. In para 350 Lordship, clause 1 and clause 2 of article 22 lay down the procedures that has to be followed when a man is arrested. They ensure 4 things. A, right to be informed regarding ground of arrest. B, right to consult and to be defended by a legal practitioner of his choice. C, right to be produced before a magistrate within 24 hours. 4, freedom from detention beyond the said period except by order of the magistrate. Lordship, what the judgment Lordship says Lordship that Lordship first he should be informed about his ground of arrest. Secondly, he so that he can right to consult. He can consult one counsel of his own choice. Thirdly, Lordship, within 24 hours he is to be produced, and if anything more time it is required, that can just get permission of the Honorable Court also. So Lordship here, so 22(1). That marks only Lordship. So Lordship here here also Lordship, it is a constitution based judgment Lordship, and it is nowhere stated that article 22(1) has to be complied. The ground of arrest has to be informed in writing Lordship. Hereafter, Lordship, on last occasion, Lordship, I mentioned about a judgment, Lordship, and that is Lordship 1966, AR 1966. But that is also constitution then judgment, Lordship, 19 AIR 1966. SC. I have given that is. That is Lordship. The second one was AIR 1966 SC 1910. State of Madhya Pradesh versus Sobhara. Here, Lordship, para 22, Lordship, I would like to read it, Lordship. Yeah. Was para 22, Lordship. That is Lordship, Hidayatullah Zarura. M. Hidayatullah. Okay, Lordship. Para 22. I consider that there is a room for further deliberation on the point. I do not see how we can differentiate between arrest of different kinds. Arrest is arrest, whatever the region. Insofar as the first part of Article 21 is concerned, it enacts a very simple safeguard for the persons arrested. It merely says that an arrested person must be told the grounds of his arrest. In other words, a personal liberty cannot be curtailed by arrest without informing him as soon as is possible why he is arrested. Where the arrest is by warrant, the warrant itself must tell him why it is by an order. Where it is by an order, the order must tell him, and where there is no warrant or order, the person making the arrest must give that information. However, the arrest is made, this must be done, and that is all that the first part of Article 22(1) lays down. I find nothing Article 22(1) to limit the requirement to arrest of a particular kind. A warrant of a court and an order of any authority must show on their face the reason for arrest. Where there is no such warrant or order, the person making the arrest must inform the person the reason of his arrest. In other words, Article 22(1) means that it says it in its first part. So, Lordship, if he is being informed, if you are also nowhere mentioned, Lordship, there are Lordship, para 22 last part is also that is also same, they say same thing, Lordship. There A.K. Kupalan judgment also mentioned here in Lordship. Para 23, Lordship, there Basawat judgment, Lordship, Basawat judgment, para 23 also says Lordship. So, Lordship, here in this case, Lordship, I found, Lordship, that Lordship, there is no, if there is no way mentioned that the Article 21, mandate of Article 21 has to be in written form. But subsequently, Lordship, when it comes, Lordship, that Pankaj Bansal judgment came, Lordship. The Pankaj Bansal judgment came on, Lordship, that is, Lordship, 2023 SCC Supreme SC 1000 actually. SCC SC Supreme SC 1000. Here, Lordship, the last, 35, there are 35, Lordship. Para 35, Lordship, that may I read that part, Lordship. On the above analysis, to give true meaning and purpose to the constitutional and statutory mandate of section 19(1) of the Act of 2002 of informing the arrested person of the grounds of arrest, we hold that it would be necessary henceforth that a copy of such written henceforth that a copy of such written grounds of arrest is furnished to the arrested person as a matter of course and without completion. So, Lordship, this is Lordship, it says, Lordship, we are going to be reading out all the paragraph, Lordship, henceforth a copy of Lordship. Because Lordship, from that day, because as all documents are retrospective effect, but here the limit has been given, as mentioned, henceforth Lordship. And that has been subsequently confirmed by the R.K. Arora case, Ramkishore Arora. That is, Lordship, 2023 Supreme SC. 2023 Supreme SC 1230. So this is R.K. Ramkishore Arora versus Director of Enforcement, Lordship. And here in para 23, Lordship, that Pankaj Bansal judgment has been mentioned, Lordship, and it has been elaborately mentioned, Lordship. As the para 23, as desiring from the judgment in Pankaj Bansal case, also noticing the inconsistent practice being followed by the officers arresting the persons under section 19 of PMLA directed to furnish the grounds of arrest in writing as a matter of course. Henceforth, meaning thereby from the date of the pronouncement of the judgment, the very use of the word henceforth implied that the said requirement of furnishing ground of arrest in writing to the arrested person as soon as after his arrest was not the mandatory or obligatory till the date of the said judgment. Was not the mandatory or obligatory till the date of said judgment. So R.K. Arora has some more clarified till the date of the judgment of the Pankaj Bansal, which was not mandatory giving the written ground of arrest first. So thereafter, Prabir Purkastha and Vihan Kumar came. Wherein in Prabir Purkastha and Vihan Kumar both have stated, Lordship, that Lordship written ground of arrest is required. Vihan Kumar, Prabir Purkastha said, differentiated the ground of arrest, reason of arrest. Differentiate. And Vihan Kumar has something some more ahead of that. Lordship, the ground of arrest has to be in the form of the language the accused person knows. The language the accused person knows, that has also been mentioned, Lordship. So, Lordship, these are the time to time, Lordship, some development of the that's our development, Lordship. So, but Lordship, the originally what was there, Lordship? The originally that the ground of arrest has to be informed to the arrested person. Subsequently, in Pankaj Bansal, it came that henceforth it will be written. There the Prabir Purkastha define it is differentiate that region of arrest and ground of arrest. But when I read out the judgment of Sobharam, Constitution bench judgment, Lordship will find in para 22, Lordship, that Lordship, there is somewhere it is mentioned ground of arrest, somewhere it is a region of arrest. That means there is no, that judgment has not differentiated the ground of arrest and region of arrest. So, as Honorable Apex of Constitution bench has not differentiated that ground of arrest, region of arrest, but subsequently it has differentiated, Lordship. But in Vihan Kumar, Lordship, in Vihan Kumar case, some points are in favor of us also, Lordship. It is not that, Lordship, Vihan Kumar is totally against the prosecution or against the. It is some point, Lordship, that Lordship, para I would like to mention in para 15 also, Lordship. In para 15 in Vihan Kumar case, that is, Lordship, that my judgment is lost. Lordship, 2025 SCC. 2025 SCC online, SC 269. that in para 15, Lordship will find the Pankaj Bansal judgment has also been discussed, Lordship, in Bihan Kumar. What it says, Lordship? We have already we have already referred to what is held in paragraph 42 and 43 of the decision in the case of Pankaj Bansal. That's just probably that is Lordship. So Lordship, in Bihan Kumar also, Lordship, in para 31, Lordship, then Lordship mainly come to 31. That is a essential part, Lordship. In 31, Lordship, it is stated, Lordship, 15, Lordship, because I was mentioning that 15, Lordship, because Lordship, in the 15 last part, there is a observation that the police have to balance the right of a person arrested with the interest of the society. That is mentioned. So when the person is caught red-handed with NDPS substance, the right of the person arrested, that has to look into. At the same time, the society interest of the society has also be look into, Lordship. We are not that everything will go in favor of the arrested person. In para 31, Lordship, in para 31, Lordship, it is one line I would like to from the middle part, Lordship. When a violation of Article 22(1) is alleged with respect to the ground of arrest, person was in ground of arrest, there can be possibly two contentions raised. One, that the arrested person was not informed of ground of arrest. First. Secondly, purported information of ground of arrest does not contain any ground of arrest, but we are facing regularly. The main claim is that that has been submitted furnished, but that is not the ground of arrest. Dear letter on, Lordship, as far as the first contention is concerned, the person who is arrested can discharge his burden by simply alleging that ground of arrest were not informed to him. If such an allegation is made in the pleadings, the entire burden is on the arresting agency or the state to satisfy the court that effective compliance was made with the requirement of Article 22(1). Therefore, the view taken by the High Court is completely erroneous. But this was regarding the first part, when person will claim that ground of arrest was not furnished to me. But when the second part, that has not been discussed in the Bihan Kumar judgment, that the ground of arrest has been furnished, but it is a purported one. Regarding that, what will be the consequences, that has not been done. It is para 31, starting that the learned single judge unfortunately has.
Okay.
That part, Lordship. The second part has not been discussed, Lordship. Thereafter, para 21, the conclusions. What the Bihan Kumar's conclusion, Lordship. This is the findings of the Bihan Kumar judgment, Lordship. That para 21, Lordship, I would like to read out the para B. The information of the ground of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. The mode, this is important, Lordship, the last line, the mode and method of communication must be such that the object of constitutional safeguard is achieved. The mode and method, there is no any, that means in such a way, it has been stated, Lordship, that the mandate of Article 21, 22(1) is complied with. So, Lordship, in case to case, it will vary. When a person is caught red-handed in a UAP Act, he do not know why he has been caught. Because sometimes he moves around and he is somehow related, he caught. But then the mode and method is to be, it has to be elaborate. But person who is carrying with NDPS substance, going to deliver it, he has been caught red-handed, commercial quantity, 180 days period, then his method will be different. So the method, how we are furnishing him, that is sufficient knowledge for him that he has been caught red-handed for the NDPS substance, Lordship. So, Lordship, this is Bihan Kumar. Thereafter, Darshan came, Lordship. In Darshan, Lordship, in para 20.1.7, Lordship, it is stated, Lordship, mentioned, Lordship, There are some other judgment, Lordship. I am, this time is very short, Lordship. I could not go because when the first one come, when the second one will be per inquiry, and that will, all these are I have prepared, Lordship. But today it is not possible because time is very short, Lordship. In Bajaj Airlines also, Lordship, it has constitution amendments 2025, Lordship, it has stated, Lordship. But Lordship, Darshan Kumar has started something very much elaborately, Lordship. It is a ratio, some ratio has been laid down that in 20.1.7, Lordship, it has stated, Lordship, that if the soon after his arrest, the person is being represented by counsel, then the mandate of Article 2 is complied and he is not demonstratively prejudiced. The word demonstrable prejudice in para 20.1.5, it is stated, Lordship, that while section 50 CRPC is mandatory.
This is in the case of
20.1.5.
which case?
This is also Karnataka, state of Karnataka versus Sri Darshan, etc. EPC. While section 50, 20.1.5.
Yes.
While section 50 CRPC is mandatory, the consistent judicial approach has been to adopt the prejudice-oriented test when examining alleged accused person lapses. The mere absence of written grounds does not ipso facto render the arrest illegal unless it results in demonstrable prejudice or denial of fair opportunity to defend. And thereafter, 21.7. In the present case, 20.1.7. In the present case, the arrest memos and remand records clearly reflect that the respondents were aware of the reasons for their arrest. They were legally represented from the outset and applied for bail shortly after his arrest. Therefore, evidencing an immediate and informed understanding of the accusations. No material has been placed on record to establish that any prejudice was caused due to the alleged procedural lapses. In the absence of demonstrable prejudice, such as irregularity is at best a curable defect cannot by itself warrant release on bail. So, Lordship, if person is demonstratively, person is being represented, because the requirement itself in A.K. Gopalan case also it is confirmed that so that he can engage one counsel. And in the second part also, Article 22, same thing has stated that he can engage one person. So when person is being arrested here, in some cases, the demonstrable prejudice, what I think I understand, Lordship, that maybe correction, that in a case of, suppose in a case of simple assaulting or something, where there is a punishment of 60 days, he may be released on 10 days also itself. He may be released on 10 days itself because there is a possibility. So in that case, Lordship, till then he will be demonstrable prejudice because in that case, if he cannot engage his counsel within 2 or 3 days, then he will be demonstrable prejudice. But in a case where commercial quantity is involved, 180 days statutory period is involved, whether within how many days he will be demonstrable prejudice. No, he may probably, Lordship, he will be within 40 days also, he will be demonstrative. He may not be allowed to go on bail because when there is a commercial quantity recovered from his possession involved. So, Lordship, here in our case, present case, his counsel appeared within 26 days. I have checked the LCR. His counsel appeared within 26 days, and prior to that, Lordship, one remand advocate was also engaged from the court side. So, Lordship, within 27 days, his counsel appeared, and prior to that, on the same day, remand advocate was also engaged by the court side. So, Lordship, here when 180 days period is the statutory period, so till 30 days, 40 days, 50 days, demonstrable, he will not be demonstrable prejudiced, Lordship. And Lordship, later on, the judgment, new judgment, Lordship, on that the Lordship has marked, Lordship, I have also gone through the judgment, Lordship. And that is, Lordship. And Ahmed Mansoor case, Lordship, that is an order, Lordship. Present case. present case, Ahmed Mansoor case, Lordship, that on that also, Lordship, that is one Lordship. It is Lordship, this is an order of the Honorable Apex Court, Lordship. This is not reported even, Lordship. Ahmed Mansoor and others versus the state represented by Assistant Commissioner of Police. Here, Lordship, I have not found any ratio laid down by this judgment order, Lordship. Only some Bihan Kumar has been discussed. Kasi Reddy has been discussed.
No, it has been.
Bihan Kumar, Kasi Reddy, and Darshan has been discussed. And even the discuss what part, Lordship, which part is goes against it. But the main observation is not being discussed here in this case, Lordship. Because while discussing the Darshan's judgment, Darshan's case is that, Lordship, that he has not been immediately furnished with the ground of arrest. But here it is mentioned he has been immediately furnished. In Kasi Reddy also, Lordship, I have not mentioned the Kasi Reddy judgment, Lordship. That is also important, Lordship. Very interested, Lordship, he is being informed. Para 27 it is here mentioned, but para 28 says something in Kasi Reddy case.
We'll continue tomorrow. Yes, sir. Mr. N.K. Murel and Council for the Petitioner is present. The submissions of Mr. K. Lakan and additional PP remains inconclusive. This Tom Swenson, tomorrow, 1/11/2025.
Tomorrow, Lordship, I on that tomorrow and to Monday, Lordship, I'm going somewhere, Lordship.
Be very difficult.
On Tuesday, if possible. My part is almost completed.
Can you give a short written note tomorrow by by filing it through somebody else? Because it will go to, I will not be available.
Short note, Lordship, that I can do, Lordship. By another PP will submit, Lordship. A written argument, Lordship, in the form of.
Just a bullet point note, just like today you have argued, you just give the bullet point and the paragraph numbers of the cases you are trying to refer.
Then tomorrow,
Somebody else may give it. You can just prepare. We don't, if you have inconvenience, don't even type it. You can just write by hand and give it.
I have prepared it for other cases also. Almost it is ready so that I can able to give.
Because if the matter is adjourned today, then it will go to the week commencing 17 November. This week would be too hectic. 6th and 7th, we have fixed many cases. And I am intermittently in.
Sorry, Lordship, but I have already booked some tickets for.
No, it's okay. I can understand. But once you have already have plans, try to give it tomorrow, then we'll consider.
Tomorrow, Lordship.
Tomorrow. Just say, the Gunner APB has submitted that he would be out of station. So in that case, he may give a bullet point of his submissions to be presented by his colleague. We'll then think what to do tomorrow.
Tomorrow case will be listed, or I have.
Case will be listed tomorrow. If he has any submission to make, that's it there. I have some assignments, I'll be intermittently out. That's. Okay.
Yes, doctor. SCC. কোনটি বার ফুল লেভেল নাম্বার 1 রে? 196. এই তো করেন। 1950. 1960. itu ya para. Era chiquito, chiquito, claro. Next to one ending. I will take them. Yeah, yang ending number 6. Mau apa tahu ini? Oh, kita belum nama fikir kalian mana ini berfikir. 1966, yeah, 1966. Yeah, mau ke submission na. Nah, submission por kan mo sa. Kami check picture kami.